Now, again, I have the honor of introducing the first panel guest this morning. I'll start with Bill Gallagher. Lawyer Bill Gallagher is a strategist in the area of Native government and corporate relations and an authority on the rise of Native empowerment in the Canadian resources sector. His 2010 book, Resource Rulers, Fortune and Folly on Canada's Road to Resources, analyzes how and why Natives have amassed the most significant winning streak in Canadian legal history. Gallagher has diffused Native logging tensions in New Brunswick's war in the woods and oil patch eco-terrorism in Alberta. He also helped guide Inco Voisey's Bay Impact Benefits Agreement to successful conclusion. Gallagher previously worked as a corporate lawyer in Calgary, an energy regulator, a devolution negotiator in the territories, and a treaty negotiator in the prairies. And I think you're going to talk about some of your TLE negotiations here in Manitoba. With that, Bill Gallagher.
Thank you, Mr. Commissioner. I'm honored to return to Manitoba. I see some friendly faces in the audience, which is always a relief. This is true to your bumper stickers. It is a friendly place. I was sent out here by the feds as a treaty land entitlement negotiator. There was a happening file at the time. The drums, I've heard the drums in the rotunda, like I've been there when the drums were pounding. If you have not heard drums in the rotunda, you have to hear it to believe it. So I have skin in the game here in the sense that I was part of a major process to facilitate and to honor the treaties, which are now still to be implemented. And so I now have to go through the proper protocol of introducing myself and recognizing that we have a former national chief, Mr. Mercredi, a statesman. We have yesterday's Paul Chartrand, former commissioner of the Royal Commission, Treaty Commissioner James Wilson, elders who have taken a very serious interest in my book. I have to acknowledge Rolling River Chief Dennis Whitebird, who is a major player in my experience here in Manitoba, who is a strategist of the highest caliber. So I know there's a higher authority in the room. It's not necessarily people who are writing books and writing learned articles, and I want to acknowledge the fact that there are chiefs, counselor, and jurists, and we all have the same interest in let's get this country out of the box up and running, and everybody have their proper roles and responsibilities. So with that, I have a loaded presentation. I move fast, and I'll be on time. So I underlined the word between because I'm here on a mission to get the Keewatin case recast as a legal win. I think it's an outright legal win. It bothers me no end that I'm stuck having to say there's a few pearls buried in there. There's more than pearls buried in there. It's a legal win. So where do I point this? I just want to give, since I'm in the resources sector, I'm going to start with 3 slides that are typical to my resource presentation and end with 3 slides, but the rest is all new stuff and new for me. I don't typically show up at law schools. Right across the country, the New Brunswick election did a 180. You want to put J Division on the road to Rexton, you will get a 180 outcome. You're out of power. You'll lose an election. You now have fracking bans right across the Maritimes. Quebec and Ontario are struck an energy alliance. That's because Quebec has got the advantage with the James Bay Cree. The Ring of Fire is beyond life support. It's dead. The Supreme Court of Canada, in the middle of this, turns out a trilogy of cases. And I might just say, although I didn't acknowledge we're on treaty land, here's how I would acknowledge it since I track the Native legal winning streak. Congratulations to the Manitoba Métis for their massive win at the Forks here a year and a half ago, under a year and a half ago. A terrific win that is based on the honor of the Crown. And I'm going to say likewise, congratulations to Treaty 3, who won the Keewatin ruling just to the east of the city limits, where, in fact, another major win, the honorable management and the taking up treaty lands based on the honor of the Crown. These are 2 pivotal wins, and that's how I acknowledge that we are on traditional lands. You have former prime ministers coming out of the woodwork to say the same thing I'm saying, let's get this country up and running. You have a major occupation that maybe resolving itself up at GenPeg. You have Alberta's resources, the engine of growth, landlocked, and you have the Premier now running the lead on First Nations, taking notes from the very chief that Neil Young was mocked at going up to visit. 3 months later, he's up there taking notes. Is that right, Chief? I'll put that on the list. We're going to work on it, right? New doctrine. You wouldn't have heard this yesterday. There's something called an Aboriginal title holder out there. Okay? That's the Tsilhqot'in decision. Yukon, I just came down from Yukon where I did the devolution deal way back when. Litigation Central, and of course the North where you have the constitutionalized resource rulers all written up in major deals. Changes in the air. I was the next speaker up after the AFN crashed Parliament. If you have time after, that's a really funny story. I went through the Chief Spence, I don't know more, Chief Nepanak conferences out here. I was down on the road to Rexton. I went up to Ottawa to hear the Roger William case. I wanted to catch the closing arguments, but it was over in a day. I missed it. The Ring of Fire, we talked about that. Everybody's turning out reports on resources gridlock. I was wedged between Leona Aglukak and Joe Oliver at PDAC when the New Prosperity Mine was given the thumbs down. I told the oil sands in Fort McMurray to get with the program in March, and was recently out of the Vancouver Board of Trade, and I've just come back from, in the last 10 days, St. John's, Whitehorse, Vancouver, and here. So I'm loaded for all sorts of commentary, but I'm going to stick to why I'm here, Keewatin. When I attended the Delgamuukw closing arguments, here's what the province of BC said to the court, and Chief Justice McLaughlin was on it as a junior judge. The province of BC is negotiating out of a moral duty, a political duty, but not a constitutional duty to negotiate. Don't crystallize this as a constitutional duty or as a constitutional right. Well, guess what? It is, okay? And the country is now adjusting to rearranging the map of Canada. The Globe and Mail said the next day that land claims ruling back in 1997 was a breathtaking mistake. They were literally on the wrong page. There's the page, they're wrong, okay? Aford put his report in 10 months ago to a year ago. I just came out of a BC legal session with 100 BC resource lawyers, many of whom were native, and I put up the list of court cases that have been decided in the BC resources sector since Mr. Aford gave his report to the Prime Minister. There's 12 rulings there. First Nations have won 10. First Nations have lost 2. One's under appeal. That's a 90% win record, and that's what I said to the BC lawyers. This is what you're selling your clients, right? This is a win-loss record of 90%. There are cases in here, never mind that as an appalling statistic, there are cases in here on tree farm licenses, okay, Haida, and the Tsilhqot'in Chief mine, okay, both have already been clarified at the Supreme Court of Canada. They're still litigating stuff that has been clarified at the Supreme Court of Canada in BC. So I'm just pointing out that would indicate that the legal toolbox is out of gas. Now here's how I switched to Keewatin. So that was my opening remarks as a resource guy. Here's the earliest, in my world, reference to honor of the Crown in terms of my research. This is out of the order in the Colonial Office instructions to the Hudson's Bay Company here in this neck of the woods. This applies to this territory. You were to consider how the Indians and slaves may be best instructed in and united for the Christian religion, both for the honor of the Crown and the Protestant religion itself, that all persons within our territory should never so blah, blah, blah. You get it. So it's in 1670, we have an honor of the Crown doctrine enunciated here at the Forks, okay? And you have a win at the Forks based on honor of the Crown a year ago. So I'm trying to make connections, right? There's Rupert's Land. We're on it. We're in the map. And when Canada purchased Rupert's Land, guess what? It came with a condition. Canada had to step up to the plate and compensate. Settlement will be considered and settled in conformity with the equitable principles that have uniformly governed the British Crown in dealing with Aborigines. So this area did not acquire Rupert's Land without a condition. That's it, the equitable principles of how this country has evolved. When Sir John A. Macdonald left the prime ministership and became the Superintendent General for Indian Affairs, here's what he said at the time when you guys joined Confederation and BC. This is around the same time. So this is back in 1883, and here's what he's saying. It is now over 100 years since the first treaty was made with Canadian Indians for the quieting of Indian titles. Here's the guy that set this country up, the first prime minister, and that's how he's talking about his relationship with First Nations. The quieting of Indian titles. He goes on to say, the Indian saw himself regarded as an equal in all the treaties, Mr. Mercredi, and the rights and privileges guaranteed to him have been observed to the very letter. So he's given himself a pat in the back. I'm coming along and I'm saying, so we shouldn't be surprised when the court is adding its layer of consistency to early recognition of Indigenous land rights and fair play principles. This next quote is from the Sir John A. Macdonald as well. I could have put it on the other slide, but it would have been too crowded. Confidence has taken deep root amongst Canadian Indians who have learned that the pledged word of the Great Mother or her lawful representatives is a bond that will not be broken. So there's the terminology back in 1883. Here's my take on how this country has evolved in terms of fair play principles. It's been a progression. We didn't start off fair play. We've worked our way up to having fair play. The peace and friendship treaties in the Maritimes do not cede land. They're all about trying to get the First Nations not to rejoin the French or to be neutral towards the English. They're full of stuff where First Nations get the benefit of the doubt, and those treaties are constitutionalized. The Royal Proclamation came along to add a layer of protection on that called, no more frauds and abuses, okay? There was all these early court cases of fair play presumptions and interpretations and contra-preferential rule and all that sort of stuff. Because you wrote the treaty doesn't mean you get to interpret it. The Indian Act, which I have no use for, actually has some protections for First Nations in it. That was part and parcel of the colonial headspace that was around at the time. Treaty land entitlement, when I get sent out, it was to protect First Nations land rights and to quiet Indian title. It happened right here in your neck of the woods. It was a big part of the evolution of protections. Then you have the court cases that come along, Marshall, where they read in the oral promises. That's more protection. Haida, duty to consult, duty to accommodate. Then the honor of the crown win with the Métis. That's another major step up and elevation of protection. And then, this is why I underline the word between. We should be able to say Keewatin, the honorable management and the taking up of treaty land under treaty. I maintain that that is the reason why it is a legal win, and it has been given short shrift right across this country. Now, we'll never get to the United Nations Declaration, but if we ever do fully embrace it in this country, it will be the icing on the cake as how this country is evolving in terms of First Nations protections. Okay? Now, I'm going to let the cat out of the bag here. If you want to get to the United Nations Declaration, the bridge to getting there is the Keewatin ruling. And if we don't want to squeeze that ruling in between where it's supposed to go, we are short-circuiting our ability to embrace the United Nations Declaration. So that's why it's very important to me that you understand this evolution, why Keewatin is important, and why it's a bridge to the United Nations Declaration. The Countess of Wessex just went up to KI country, Kitchener-Wakusak-Innuit, where I have a personal history. And she said, upon her return just last month, even today, our Queen is referred to as a Great White Mother, and the enormous respect in which she is held remains. So the same terminology applies, the same relationship applies. Our brand new Lieutenant Governor in Ontario, Dowdeswell, had this to say as she read the throne speech and took her office. The world's most important problems are Ontario's most fundamental challenges. She was up on the trip to KI country. She has previously worked at the United Nations, which she said helped shape her worldview. So you can see how I'm linking the very first contact, the Hudson's Bay stuff, to the Prime Minister's stuff back in 1883, to recent major disconnects in Ontario today to people showing real statesmanship and leadership. We're still trying to get this country out of the box. It's all linked, and all the same terminology is very current and very relevant. And we heard some of that yesterday from the former national chief. Okay, what's going on? Okay. The Chief Justice has now written a trilogy of major court cases. She has written them. They're all unanimous. Métis, Aboriginal rights, Tsilhqot'in, and treaty interpretation, Keewatin. I maintain they're meant to be read in a complementary fashion. I also maintain, to the professors in the room, that she is legally and factually bulletproof in her reasoning. I have offered to publicly debate the fact that Keewatin is a legal win. The only condition is it has to be in Calgary. And I'll get to that, but nobody's taken me up on it. I maintain that these are 3 unanimous full court outcomes: the Chief Justice's trilogy, her legacy, and she's showing tremendous legal statesmanship. It's not a coincidence that this is happening at the apex of legal, it's not a coincidence that the apex of the Supreme Court of Canada legal reasoning is occurring at the apex of the rise of Native empowerment. They're showing the way forward. Of the 3 cases, 2 of them apply here. We'll hear more on that later. 2 apply right to this locale. All 3 apply the foundational legal precepts that I have laid out: honor of the Crown, the equitable principles. We're still in the business of quieting Indian title, big time in BC. The case for the Métis sets the stage to address compensation for land inequities, and this trilogy coincides with Natives as resource rulers. I'm not necessarily in anybody's camp. I follow the evidence, but the evidence leads me to First Nations here in Manitoba as being resource rulers. I'm quite prepared to debate that if you want to pay for my flight out. The throne speech. Okay, here's as far as the federal government is ever going to go on the United Nations Declaration. 2010, we're a country with an Aboriginal heritage. A growing number of states have given qualified recognition to the United Nations Declaration. Our government will take steps to endorse this aspirational document in a manner fully consistent with Canada's Constitution and laws. I think they should be given credit for that. I don't think they have to do holus bolus, we embrace it in an unqualified fashion. You've seen the evolution of equitable doctrines that precede the United Nations. It's up to statesmen to bring the United Nations Declaration to bear. I just say cut the government some slack on this and see it in context. It is a qualified endorsement, but it's significant. No other country in the world has the constitutional protections and the evolution of equitable doctrines than we have. We actually are an example worth studying and in some cases worth following. How to get to free, prior, informed consent. Now, the reason I'm wound up on this, okay, is I was in front of 100 BC lawyers in the resources sector, and I asked, how many of you on a resource project, this was last week, how many of you have ever asked a First Nation for consent? Or if you are a First Nation, were asked to give consent? Not one hand went up. So I said, well, I did on Voisey's Bay 12 years ago. That's a 12-year time span. Voisey's Bay is now up and running. They're going underground. They've mined the surface. They've built their hydromet smelter. It is in production this week, and everything that is happening in Have Province, Newfoundland, is not happening in Have Not Province, Ontario. And the kickoff was consent. So I don't have the heebie-jeebies about asking First Nations for consent. As a matter of fact, I think in the way the law has evolved, I think First Nations have the right to withhold consent, and I think they have a de facto veto. I'm also prepared to debate that publicly if anybody wants to take me on. Again, I prefer to do it in Calgary. So now the government gets tagged for being ideologically deadlocked on the United Nations Declaration. Well, not in my mind. We are geopolitically deadlocked on resource access, and we're landlocked on bitumen. But I'm saying, hey, hold the phone. getting to free prior informed consent is close. There are 2 express references to consent in Tsilhqot'in. You never know that from yesterday's discussion, right? We never got around to talking about redrawing the map of Canada, right? But consent is required if you're dealing with a title holder. That's the new doctrine. It wasn't discussed yesterday either, right? I'm saying, and this is the key point of my entire presentation, consent to getting to free prior informed consent should even be closer in the evolution of equitable principles if we gave proper deference to the doctrine of honorable management in the taking up of treaty lands. Instead, Keewatin has been categorized as a native side loss. Double whammy. Here's the doctrine. I went out on a campaign back at the Court of Appeal level. Lawyer argues Grassy Narrows ruling can actually help First Nations, okay? So I became a one-man band at the appellate level, and here's why. I'm not going to read the whole thing out. You can see the doctrine of the honor of the Crown. You can see that there's new wording called honorable management. The authority to take up Keewatin lands must consult and accommodate treaty rights whenever they are sufficiently impacted. And guess what? Ontario's on board with this every step of the way. That's a huge point for me. Ontario is saying, yes, Judge, we can live with that. It's a new doctrine. It's obviously built on the Mikisew duty to consult, which applies to treaties. But it acts as a clear break on the Crown's taking up power under treaty. I'm saying if you put your legal minds to it in this room, you can develop a broader legal scope and magnitude that is potentially a new standalone equitable doctrine backed up by 200 native legal wins. It's your bridge. It's potentially the evolutionary bridge to free, prior, informed consent. Something I embrace and something I think is a de facto reality of dealing with First Nations north of the Trans-Canada Highway in this country. How am I doing time-wise? The goal? Sound bites. There's me. Lawyer argues Grassy Narrows ruling can help First Nations. I think it's a significant win. It sets out major obligations when dealing with traditional First Nations territories. There's a pretty pro-Native set of rules that the Crown now has to follow. Major obligations for the Crown. Ontario agrees. When you look at the Supreme Court of Canada case that came later, in the last 4 paragraphs, you can enunciate 10 benchmark principles of how you take up lands on treaty lands. So I'm inviting legal scholars to revisit this case and put their imprimatur on it if they feel it's appropriate. I can live with the consequences. I mean, if it's still a loss, it's a loss, right? It bugs me. But if you do your homework and it is a loss, I'm not, I'll shut up, right? But I'm not done with it yet. In the lead up to the CCC, the Supreme Court of Canada, I have a trap line with national media, and I worked the editors of the newspaper, and I said, look, this court case is coming out of Keewatin. It's going to be really important on all that stuff in the Ring of Fire, all that stuff up in the Bipole 3. It's got huge issues. You should follow it. So the Legal Post wrote an editorial that said this, just before the court case came out. Legal observers will be looking to see whether the Supreme Court of Canada has anything to say about the definition or process of taking up itself. This process, which is basically expropriation with a softer name, has led to litigation involving other treaties in Ontario. Like, no kidding, right? This is the world I live in, right? Then he concluded, there's the potential for the court to surprise a lot of people. Well, the big surprise was nobody picked up on this. This court case is all about the doctrine of taking up. I want to rectify the imbalance that was struck yesterday on interjurisdictional immunity. This court case is all about the doctrine of taking up, and kudos to the National Post legal editor for at least flagging that to the reader. It's more than the legal community did. My Keewatin campaign is this. I went up to when Neil Young was getting hammered in the media for being, who is this guy and who does he think he is? He was traipsing across the country on something called an Honor the Treaty tour at the very same time that the doctrine of honorable management had been enunciated by the Ontario Court of Appeal. So I went in as a former oil patcher and reminded my oil patch colleagues that that Jurassic rocker that they were constantly dumping on might have a closer version of the way the law is evolving than their corner office partners. So that was my get with the program speech, okay? So everybody gets a fair share of my measure, right? Now, I'm in the newspaper after giving that speech saying this: I believe that First Nations have constructed an encirclement of the oil sands through a series of increasingly sophisticated legal challenges. That's me in the Edmonton Journal this February. So why am I now talking about the oil sands and the Edmonton Journal and me on my campaign in Fort McMurray? I then went on BNN and basically said that when it was dismissed as a native loss, I basically went on BNN and said, hey, it's a procedural loss, but natives are on a major resources role in the Canadian court cases. So I got my message out. But here's what I said to BNN. If you're an oil patch lawyer, and if you're fighting those court cases encircling the oil sands, here's the Chief Justice deciding the Keewatin case here, geographically here, using 3 court cases out of Treaty 8 that are north of the oil sands. So I basically say, hey, there's a clear message here for Alberta that if any one of those First Nations cases makes it to the Supreme Court of Canada, here's a glimpse as to how they might be decided. Because if the court is deciding Keewatin cases based on Treaty 8 cases out of northern Alberta, there's a very good chance that those same 3 cases will help decide First Nations cases out of Treaty 8 in northern Alberta. So heads up, oil sands. This is the slide that I showed you earlier. I'm going back. I'm putting in a slide that I showed you earlier. You can see why I see the honorable management doctrine slid in between, that's that word again, at the bottom, is your bridge to free, prior, informed consent. That's the goal. I don't particularly care if the government of Canada does sprinkle holy water on the United Nations Declaration. On a de facto basis, I want people to understand that if you're not set up to earn consent on a resource project, you shouldn't be in this line of work, because that's where things are at. And so this is a bridge, and if the legal scholarship in this country doesn't see it this way, then I'm challenging them. Take a second look at it. This is a ranking win. This is a Supreme Court of Canada win. It was a ranking win at the Ontario Court of Appeal. That court has got brain power. Keewatin is a win. It's been miscast, so double damage was done. I got chiefs in Ontario running around, oh, so Keewatin's the loss, so we're going to apply that Tsilhqot'in case up here in KI country. Everything up to now has been a missed opportunity. All the sound bites have to be reordered to undo the public relations damage. This session here is critical to reestablishing the profile of Keewatin as the bridge to free, prior, informed consent. I am looking for legal adherence and academic clout. There's the doctrine again. Again, as noted above, Ontario accepts these constitutional obligations. Okay? Why? Why is Ontario embracing this? Because Queen's Park has been on the receiving end of serious First Nations pushback on all fronts. Caledonia is back in the news. They can't build bridges on the Grand River. Ring of Fire, KI, Matawa, Nan, Ring of Fire, resource gatekeepers, mining, wind farm, all in the trash bin of history. Ontario is still mired in this resource sector time warp. Litigators rule the roost. The litigation on the Ring of Fire has gone on for so long that it outlasted Cliff's presence in Canada. Okay? I think you was talking about a legal pearl. That's really perversely funny. This is why Ontario's on side. This is the T-shirt that the OPP turned out after Ipperwash. This is a very unflattering image, but this is conflict studies. You know, we're supposed to squirm on some of this stuff. This country is not working, and we have to face the reasons why. Nobody knew about this T-shirt until the inquiry came along. It had officers crying on the stand, right? Because things look pretty stupid in hindsight. Was there a burial ground? Oh, who knew? Don't ask the Department of Justice. It turns out that this skull sat on the park superintendent's desk for a period of years. Okay? So everybody knew. One of the guys who argued the court case says that, hey, this is Ontario's win. He put it in quotation marks, comes at a high cost. While technically a loss for Grassy Narrows, this guy's Wabasgang, this decision will likely prove to be a powerful tool for ensuring that Ontario and other provinces respect treaty rights. I agree with them. It's the bridge to free, prior, informed consent. If it is the bridge, if you agree with what I'm saying, then it's critical that it be given proper recognition before it recedes from importance. Otherwise, it's a major missed opportunity just when political statesmanship is most needed. Here I am talking about a few legal pearls when I maintain it's a brand new legal doctrine. The only statesman I've heard in this room so far has been the former chief, national chief, who gave a compelling talk yesterday. Now I'm back to my resource sector wrap-up. This country needs a holistic redistribution formula where First Nations benefit on a pro-rata basis. The country needs a Ministry of Access to Resources where First Nations Secretariat is pivotal to decision-making. Thomas Mulcair had me out to address his entire caucus. He's running around with resource rulers. He has already pledged, before I presented, to create a secretariat. He came into NEPANAC's conference and said, within his first 30 days of government, he will put a First Nations Secretariat in the PMO. The country needs constructive dialogue to occur at the Prime Minister, AFN, CEO, provincial premiers level. For First Nations, you're at 197 legal wins. Get your act in gear. The Métis had one win, and they've trotted out the Richardsons and Paul Martin. They're out to commercialize their win. That's the way to go. You have to do the same thing. It's a major missed opportunity. It's not happening. Your native legal wins are being left to languish. Keewatin would be the #1 on the list. You're playing right in the hands of the status quo, beneficiaries, litigators, bureaucrats, inertia. These rulings clearly have to be implemented. To do that, they have to be commercialized. They have to be transformed into political power. Negotiations today require robust outcomes based on Crown industry natives sharing power. Again, if that word bugs you, you're in the wrong line of work. No reason why you can't green the oil sands. Here's what the Ministry of Access to Resources would look like. A specialized federal super ministry is needed because Ottawa has systematically got itself out of the resources game. It would offer key strategic advantages to federal, provincial, native balance. The Native Secretariat is a key component. The rationale for the new ministry, nothing's working. The list of project train wrecks on the road to resources, the rise of Native empowerment, ongoing and future litigation, environmental legitimacy. Eco-activists are legitimate. They're the big winner in the Ring of Fire. I mean, there is a winner. It's CPAW's Wildlands League. The country's economic priorities. It's high time to reconcile rights. Thank you so much.